Singapore has implemented 2 or 3 key amendments in terms of consent. We have broadened the concept of consent to include deemed consent by contractual necessity, where it's necessary for a company to complete the transaction, so that when an individual gives consent, that will cascade onwards, so that a delivery company, for instance, will not have to seek further consent. There are also 2 other instances which I think would be of use to companies. This include the legitimate interest exception, where organizations will be able to use the personal data without the need to seek further consent from the individual, so long as it has a legitimate interest in using that data, and that legitimate interest outweighs any adverse effects that may be suffered by that individual. Of course, we expect the organization to conduct a risk assessment prior to doing so, and will have to take the necessary remedial actions to ensure the protection of the personal data. Another exception that we have implemented, which I think will be of interest to people in this room, is the business improvement exception. This will allow organizations to use the personal data without the need for further consent from an existing customer, so long as it's to improve their goods or services. So I think apart from these exceptions, the other key point that I would like to highlight is that in terms of our enforcement approach, we have also introduced a voluntary undertaking mechanism which allows organizations to provide the PDPC a proposed remediation plan to remedy any breaches. These kind of voluntary undertakings will be considered and accepted by the Commission, provided that the organization demonstrates that it satisfies certain accountability principles, that it has the good data protection policies in place, a mechanism to respond to complaints, and we have to ensure that the remediation plan will be able to take care of the problem. Apart from the voluntary undertaking, Singapore's latest amendments to our Personal Data Protection Act actually increase the financial penalty. The existing financial penalty is up to 1 million Sing dollars, and after the amendments, the maximum financial penalty is actually 10% of the organization's annual turnover in Singapore when it exceeds 10 million. So that is a shift towards imposing a higher financial penalty in certain circumstances when it's due, so as to allow us to take the necessary response when it is needed. Of course, it has to be proportionate to the severity of the data breach and the obligation that is breached under our Act. I think I have set out certain key points. I think what I really like the audience to take away from is that the PDPC is a forward-looking regulator. We work closely with the industry and consult very closely with any reforms, and we are collaborative. So if any company has a new proposed mechanism in which they wish to use the data, we also have regulatory sandboxes which will allow us to work with a company as they develop and implement their plans. So I would like the audience to bear in mind that PDPC is always looking for new ways or the necessary ways to make sure that our personal data protection laws are up to standard, while allowing companies and businesses to use their personal data in legitimate ways.